All right, so today we are going deep on judicial review. We've got these excerpts from what looks like a legal textbook,
Hmm.
with explanations and real-world examples, so
Yeah.
perfect for us.
I think judicial review, it really is at the heart of how power is balanced
Hmm.
in our government, so it's a pretty crucial concept.
Yeah, absolutely. And, it might not sound like the most thrilling thing at first glance, but trust me, it gets pretty fascinating when you start digging into it. Have you ever, wondered who makes sure the government actually follows the rules?
Right.
Well, that's where judicial review comes
Yeah.
in.
Yeah. Like the ultimate check on government power, make sure both federal and state actions are lining up with the Constitution.
So it's kind of like a referee in a game.
Exactly. The court, especially the Supreme Court, acts as that referee. They decide if laws or government actions are constitutional.
So where does this power of judicial review even come from? It's not uh, directly in the Constitution, is it?
You're right. It's not like a super straightforward answer. Article 3 of the Constitution does set the stage by, establishing the judicial branch.
Yeah.
The Judiciary Act of 1789 kind of fleshes out the court system.
But the real turning point was Marbury v. Madison in 1803.
Precisely. It's a super interesting case, actually. It didn't explicitly, give the Supreme Court the power, but it was in Marbury that the court asserted its right to interpret the Constitution and to strike down laws they saw as unconstitutional.
Wow, so Marbury was a real power move. They basically said they had the final say on the Constitution, not the president or Congress.
Yeah, you could say that. And this power wasn't just limited to federal laws. We have cases like Martin v. Hunter's lessee. That extended judicial review to state courts, meaning the Supreme Court could review state decisions involving federal law or treaties.
And Cooper v. Aaron kind of took it a step further, right? It established that Supreme Court decisions were the supreme law of the land.
Yeah, Cooper v. Aaron was a powerful statement.
They're binding on all states, even if they didn't agree with the ruling.
Exactly. They made it clear that the Supreme Court had ultimate authority on constitutional matters.
That's pretty incredible, but I'm guessing they can't just rule on anything.
Yeah.
There had to be some limitations to their power.
Absolutely. It's not a free-for-all. There are several limitations on judicial review, one of the biggest being the political question doctrine.
Okay. Break that down for me. What does that even mean?
Basically, courts try to stay out of purely political matters. They recognize that some issues are better left to the other branches of government, the legislative and executive branches.
Hold on. Isn't that a little vague? What counts as a political question?
Hmm.
It seems like that could be open to interpretation and even abuse.
Yeah, that's a fair point. Figuring out what's a political question has been debated and refined over time through various court cases. For example, Baker v. Carr and Nixon v. U.S. both clarified this doctrine. In Baker, the court outlined specific situations where it couldn't step in, like issues directly assigned to another branch by the Constitution. And in Nixon, they decided that impeachment proceedings fell under that political question umbrella, making them non-justiciable.
I see. So the court is basically saying, hey, there are some things we just won't touch. Those are your jobs.
Exactly, drawing a line. They're saying they're there to interpret the law, not get caught up in politics.
Okay, that makes sense. What are some other limitations on judicial review?
Well, another big one is the rule against giving advisory opinions. Courts need an actual case. Real people with real problems and real stakes. Not hypotheticals.
I bet there's a story there.
Oh, there is. Back in 1911, in Muskrat v. U.S., Congress basically asked the court to pre-approve a law by answering a hypothetical question about its constitutionality.
So they wanted a sneak peek, a heads up on if the law would be okay.
Exactly. But the court said no. We need a real case with real people. We don't deal in hypotheticals.
That's actually pretty smart. Keeps things grounded in real-world issues.
Yeah.
So real cases, real people. But can anyone just walk into a courtroom and challenge a law?
That's where another limitation comes in. Standing. To sue, you can't just be annoyed by a law. You have to show you've been personally harmed by it.
So I can't just sue the government because I don't like a law. I have to show how it's hurt me.
Exactly. This idea of standing was clarified in Lujan v. Defenders of Wildlife in 1992. The court said there are 3 key things you need to prove to have standing.
Okay, hit me.
First, you need to show you've suffered a real specific injury. Second, you have to prove there's a direct connection between that injury and the law. And lastly, you have to show the court can actually do something to fix it.
So you can't just dislike a law. You have to be actually harmed by it, and the court needs to be able to fix it.
Exactly. This keeps the courts focused on real problems, not theories.
All right, so we've covered the political question doctrine, advisory opinions, and standing. Any other important limitations on judicial review?
Two more: ripeness and mootness.
Okay, let's break those down. What do they mean?
Ripeness is about timing. A case needs to be developed enough for a court to make a decision. It can't be too early, based on speculation about future harm.
So no jumping the gun.
Right.
What about mootness?
Mootness is the opposite. If a case is moot, the problem's gone. Maybe it was resolved or things changed.
So the issue fizzled out?
Pretty much. The court will likely dismiss the case because it's not relevant anymore.
So the timing has to be just right.
Exactly. Ripeness and mootness ensure that judicial review is used properly for real legal issues.
Lots of checks and balances here. So the court acts as a referee, but
Right.
what about Congress? Can they push back against the courts, influence the game a bit?
Things get even more interesting there. Congress can limit what kinds of cases federal courts can hear. It's a balance of power, but there are limits. Constitutional boundaries.
So they can try to nudge the courts, but not control them or tell them what to rule on.
You got it. A classic example is Ex parte McCardle from 1869. It happened during Reconstruction after the Civil War. Involved a newspaper editor, William McCardle, who was arrested by the military for articles criticizing Reconstruction policies.
Sounds like freedom of the press versus government authority.
Yeah, you could say that. McCardle argued his detention was illegal and wanted a writ of habeas corpus, the right to challenge your detention in court. His case went up to the Supreme Court, but while they were waiting, Congress repealed the part of the law. That gave them the power to hear those kinds of habeas corpus cases.
Wait, so Congress changed the rules in the middle of the game?
They did, put the court in a tough spot. They could defy Congress and risk a constitutional crisis, or yield to Congress, limiting their power.
So what'd they do?
Surprisingly, the court upheld Congress's power in that case. They acknowledged Congress's authority to decide what kinds of cases they could hear.
So does that mean Congress controls what the Supreme Court hears?
Not completely. McCardle showed Congress has some power over the court's jurisdiction, but it has to be within constitutional limits. They couldn't, for example, stop the court from hearing cases about a certain right.
So it was like a balancing act.
Exactly. A delicate balance that's still being figured out today.
This is all so fascinating. I'm starting to see how important judicial review is in our system.
It is, and we've really just scratched the surface. So much more to explore in this world of checks and balances and legal power plays.
So we've talked about the principles and the limits, but I'm really curious to see how these play out in real cases.
Well, let's revisit Marbury v. Madison then. It's considered the cornerstone of judicial review, and it's kind of a captivating story full of political maneuvering and legal brilliance.
Okay, I'm all ears. This case is like the OG of Supreme Court showdowns.
Exactly. Just imagine it's 1801. We've got this really dramatic presidential election happening. John Adams and the Federalist Party are on their way out, defeated by Thomas Jefferson and his Democratic-Republican Party.
Wait, John Adams? Wasn't he one of the founding fathers, like one of the guys who wrote the Constitution?
He was. But even founding fathers can get caught up in political drama.
Haha. I guess that's reassuring in a way. So what happened with this election?
Well, in the final days of his presidency, Adams and his party went on an appointment spree, creating new judicial positions and filling them with Federalist loyalists. They were trying to hold on to some influence even though they'd lost.
Little last-minute power play. I can see where this is going.
Right. These appointments were approved by the Senate, but they had to be officially delivered by the Secretary of State, who at that time was John Marshall, another prominent Federalist.
Hold on. John Marshall, isn't that the guy who became one of the most influential Chief Justices?
That's him. So here we have Marshall, a staunch Federalist himself, scrambling to deliver these commissions before Jefferson takes over. But he runs out of time. Some of the commissions, including one for a man named William Marbury, they were left undelivered when Jefferson became president.
Ooh, I'm sensing some tension. Jefferson was probably not happy about these last-minute appointments.
I got it. Jefferson was definitely not keen on letting these appointments stand. He told his new Secretary of State, James Madison, to hold back the remaining commissions.
So what did Marbury do? I doubt he just gave up.
Of course not. Marbury felt cheated. He went straight to the Supreme Court, argued he had a right to his commission, and demanded the court issue a writ of mandamus, basically a court order forcing Madison to deliver it.
And this is where Chief Justice John Marshall steps in.
Exactly. Now, Marshall's facing a dilemma. Sympathetic to Marbury's claim as a fellow Federalist, but he also knew challenging the new president could cause a huge crisis.
Caught between a rock and a hard place. So what did he do?
Marshall came up with a brilliant solution. He wrote an opinion that seemed to side with Jefferson, while simultaneously establishing the power of judicial review. He agreed that Marbury had a right to the commission, and that Madison should have delivered it.
So Marbury won. End of story.
Not so fast. Here's the clever part. Marshall then declared that the part of the Judiciary Act of 1789, the part that gave the Supreme Court the power to issue those writs of mandamus, well, he said that part was unconstitutional. It contradicted Article 3 of the Constitution, which defines the court's original jurisdiction.
Wow. So he outsmarted everyone. Ruled for Jefferson by striking down the very law Marbury was using.
Precisely. By declaring part of the Judiciary Act unconstitutional, Marshall avoided a direct fight with Jefferson, but he also asserted the Supreme Court's power to review laws and determine their constitutionality.
Genius. So Marbury might have technically lost, but Marbury v. Madison established the principle of judicial review, making the Supreme Court the ultimate interpreter of the Constitution.
A pivotal moment in American legal history.
Okay, so we have judicial review, thanks to Marbury v. Madison. What other cases helped define this power over time?
Remember how we talked about judicial review applying to state courts too?
Yeah, it's not just about the federal government.
Right. A key case showing this is Martin v. Hunter's lessee from 1816, stemming from a land dispute in Virginia, with huge implications for the balance of power between federal and state governments.
Oh, a land dispute. I love those.
Uh-huh. Well, there were two conflicting claims to this big piece of land. One claim was based on a grant from Virginia, the other on a treaty between the U.S. and Great Britain.
So state law versus federal treaty. Sounds like a showdown.
It went all the way to the Supreme Court. They ruled for the claim based on the treaty, asserted their right to review state court decisions involving federal law, confirmed federal law trumps state law when they clashed.
So they're the final word, even in state disputes.
Exactly. Martin v. Hunter's lessee really cemented that idea. The Supreme Court has the final say on the Constitution and federal law.
This is so interesting. These early cases really set the foundation for our legal system. But it wasn't always smooth sailing, right? Were there challenges to judicial review?
Oh, absolutely. There have always been debates about it. Some people say it gives unelected judges too much power, letting them overturn the will of the people.
I can see that. Raises questions about democracy. If courts can strike down laws Congress passes, are they overstepping?
It's a valid concern, and it really came to a head in Cooper v. Aaron in 1958, during the Civil Rights Movement, about desegregation of schools in Little Rock, Arkansas.
Oh, right. This was after Brown v. Board of Education, where they said segregated schools were unconstitutional.
Exactly. Cooper v. Aaron came a few years later and really tested the court's power to enforce its decisions.
So what was happening in Little Rock? If the court already ruled, why was there still resistance?
Many states, including Arkansas, resisted, even after the ruling. In Little Rock, the governor called in the National Guard to stop 9 black students from entering Central High School. Really tense situation.
Wow. They were directly challenging the Supreme Court.
They were.
What did the court do?
In Cooper v. Aaron, the court issued a very strong decision. Unanimous. They said their rulings on the Constitution were binding on all states, no matter what. They said their interpretation was the supreme law of the land, and no state or local government could defy them.
A powerful statement. You can't ignore us.
Exactly. Cooper v. Aaron solidified the Supreme Court's authority, a warning against undermining the court.
These cases are fascinating. Seeing how judicial review has been shaped and tested, from Marbury to Cooper v. Aaron, it's like a legal drama.
And it doesn't stop there. So many other cases have added to our understanding of judicial review. It's an area of law that keeps evolving, reflecting the changing world and the role of courts in a democracy.
You know, it's really interesting to see how these cases, they highlight the push and pull between the different parts of government. Like we see how Congress sometimes tries to test the boundaries of the court's power. Are there other examples of this kind of thing?
Oh, definitely. Remember how we talked about Congress being able to control which cases federal courts can even hear? It's led to some really interesting legal battles.
Yeah, we talked about how Congress can't just eliminate judicial review, especially when it comes to basic rights, but they can try to influence what the courts rule on.
Right. And Ex parte McCardle, that case with the newspaper editor during Reconstruction, that's a perfect example of this back and forth over jurisdiction.
Can you remind me about the specifics of McCardle?
Sure. So William McCardle was arrested by the military for publishing articles that were critical of Reconstruction. He wanted a writ of habeas corpus, arguing that his detention was illegal, so his case ends up at the Supreme Court. But while they're waiting for a decision, Congress steps in, and they repeal the law that gave the Supreme Court the power to hear those habeas corpus appeals from military courts.
So they changed the rules mid-game.
Pretty much. It was a strategic move to limit the court's power. And it put the court in a difficult position. They would defy Congress and potentially cause a constitutional crisis. Or they could give in to Congress's attempt to limit their power.
What a dilemma. So what did they decide?
Well, in a kind of surprising move, the court actually upheld Congress's power in that specific case. They said that Congress did have the authority to decide what types of cases the Supreme Court could hear on appeal.
So does that mean Congress can just tell the Supreme Court what to do?
Not quite. Ex parte McCardle shows that Congress does have some control over what the court can hear, but it's not absolute power. The court emphasized that this authority has to stay within the Constitution. Congress couldn't, for instance, completely prevent the court from hearing any cases about a particular right.
So there's a balance.
Exactly. Congress has some influence, but they can't overstep and undermine the court's essential functions, especially when it comes to protecting people's rights.
It's really amazing how these cases show this constant negotiation of power between the different branches of government, this back and forth, this legal tug of war to make sure no one part gets too powerful.
Exactly. Judicial review, with all its intricacies, is a crucial part of that balancing act. It helps keep the government in check and protects our freedoms.
You know, it's so clear from all this. That judicial review is more than just some abstract legal idea. It really has an impact on our laws, our government, our lives.
Absolutely. And we've just touched the surface here. There are so many other interesting cases and legal concepts that have helped us understand judicial review. It's an area of law that's always changing as society changes.
Well, that wraps up our deep dive into judicial review. We've explored landmark cases, the limits of the court's power, and how the different parts of government interact. Hopefully you've got a better grasp on this essential concept now.
We've seen how it acts as a safeguard, making sure the government follows the Constitution, and how it's crucial for protecting our rights and freedoms.
We've also learned that it's not a one-way street. Congress has a role to play, and that back and forth is what keeps things in balance.
It's a really fascinating system, all designed to maintain that delicate balance of power.
So next time you see a Supreme Court ruling or hear about the Constitution, think about the power of judicial review. It's shaped our history and still impacts us in so many ways.
It's a testament to the foresight of the Founding Fathers, who made a system designed to adapt and change with us.
And on that note, I'll leave you with one last thought. Remember Muskrat v. U.S., where the court refused to give Congress a preview of how they'd rule on a hypothetical law. It shows how seriously the court takes its role.
Right.
They're there to decide real cases with real impact, not give advice or get lost in theory.
It's a good reminder that even with all its complexity, our legal system is about justice and protecting people's rights.
So stay curious, keep exploring, and never underestimate the power of the law. Until next time, keep diving deep.